It's my great pleasure to introduce Dame Hazel Genn, who was with us. The title of her talk is Access to Justice: Who is Missing Out? The Promise of Technology and the Role of Justice Actors. Dame Hazel is a leading authority on civil justice, and her work has had a major impact on policymakers around the world. She is a professor of socio-legal studies at the Faculty of Laws at the University College in London. She was the dean of the faculty from 2008 to 2017. And in 2013, she created the Center for Access to Justice, and she serves as the director of that center now. In doing some research about Dame Hazel's work, I was really taken by so much that she has done and what a leader she is in civil access to justice around the world. I came across a talk that she gave a little over a year ago, a Bentham lecture on what she's doing with the clinic in developing health justice partnerships, what we call in the United States medical legal partnerships. And if you have some time, I recommend this talk. It was really so wonderful to watch Dame Hazel and to learn about this innovative work that she's doing at the clinic, really creating this partnership to show that having a lawyer has real health benefits for people around the world. So thank you so much, Dame Hazel. And without further ado.
Thank you. That's a very generous introduction. Very sweet of you. Very pleased to be here. Always slightly concerned about following Richard because while I am always enthused by his presentations, I often see myself as a slight corrective, a little bit of a reality check. So I think he's somewhere further down the line than I am. And I've been asked to think about the role of technology or the potential for technology in the context of access to justice. Now, Richard spoke about it, but I want to focus in a little bit more detail about what we mean about access to justice and who are the people who are currently being excluded from our justice system. So I want to flesh those things out. And I want to include both courts and tribunals in my consideration, because of course it's not just courts that are going online, it's also tribunals. Now, in thinking more closely about access to justice and those people who are left out of the justice system, this inevitably leads me to the more difficult end of the justice system business, where justice system works to enforce rights and protections for the poor and vulnerable, the people for whom law is the only resort, if only they know their rights and they know how to use them. It's the end of the justice system where actually technological innovation has not strayed very much. But I believe that there are real opportunities to make the justice system more accessible for those who are harder to help, and where there are tools being developed to support the legal actors who support those who cannot yet help themselves. So I don't think we're yet at Richard's vision for the future, where you don't have the lawyer bridging the gap. And I'm going to say more about those gaps. So I want to say a bit about who needs access, why, and what does technology offer. My starting point is always to remind ourselves, I've got a slightly different formulation of access to justice from Richard. For people to have effective access to justice, they need to know their rights. They need to have a sense of what options there are for redress or for dispute resolution. They need to be able to effectively engage in those processes, and they need to achieve just outcomes by means of conspicuously fair procedures. Now, the justice system covers, or the justice system is there to serve a very wide range of people. And when we talk about access to justice reform, when people like Richard get excited about online courts and disputes, the question is, who do we have in mind? So the justice system is there for many different kinds of disputes, business to business disputes, consumer to business disputes, people who have accidental injuries and who are suing institutions. But then we also have the vast range of issues that people at the lower end of the social scale have to deal with. People who are dealing with issues to do with mental health, discrimination, domestic abuse, housing problems, benefits. These are people for whom the law provides a solution when nothing much else will. And we also need to remember that the vast majority of people who are within the justice system as individuals appear as defendants, not claimants. So we need, when we're talking about how online courts are going to help make life much easier, create much more access to justice, we need to think, who do we have in mind? We're also talking about a situation where we've got lots of technology, but we've also got an increase in deprivation. Deprivation, people who are suffering deprivation have problems in accessing all of the things that make life bearable to live. Things to do with income, employment, health, housing, living environment and security. And the law has something to say about all of these things. The law provides critical protections, entitlements and services for those people who are struggling to get themselves out of deprivation and to be included in society. So this image, we have to remember that there are very many different types of individual, different types of need, and different types of capability. And in this context, I think that constantly talking, in the context of technology and online courts, constantly referring to the digital divide is a massive oversimplification and a failure to understand what in commercial terms people talk about customer segmentation. And I've thought a lot, I've done a lot of empirical research. I've spent a lot of time hanging around courts and tribunals, and I've spent a lot of time talking to people about their legal problems and their legal needs. And there are very different categories of people that if we want to increase access to justice, we have to be able to serve, and to serve in different ways. So we have the literate capable experience. And here experience means experience in terms of using the justice system. We have the literate capable. We have literate people with low capability. They're often people who are generally capable, but because of the seriousness of the problem with which they are faced, they literally become paralyzed. They don't know what to do. We have low levels of literacy and capability, and we have people who are not literate. 16% of the adult population of England and Wales are functionally illiterate. That means they do not have levels of literacy that make it possible to work properly. So, and the other thing we know from legal needs studies is that legal problems are disproportionately experienced by those people who have the least capability to resolve. So this isn't, I'm not talking about access to I am talking about access to computers. I've heard Richard say that even the homeless have handhelds. But the question is, what are they using them for? So I'm not just talking about levels of computer literacy, I'm talking about levels of literacy, basic literacy, and ability to understand the things that you're reading. And this is important in the context of online courts. So what's the access to justice problem? Richard has explained it. I don't disagree. We've got massively complex court procedures and even fairly complex tribunal procedures for people with low levels of capability. We're paper heavy. We've had a massive loss of legal aid, and we have a rush of litigants in person. The rush of litigants in person into the courts, however, are those people who've got the energy and capability to get themselves into the courts. What about all of those people who don't get anywhere near a court or tribunal? In case you don't know, you haven't seen my little pie chart, between 2010 and 2016, the Ministry of Justice lost 1/3 of its budget. That is the largest loss of it's almost the largest loss of any government department. And of course, what happened during that period is that legal aid was savaged, and that people with welfare benefits, social problems were excluded from the legal aid system. The other effect of that is that because of the loss of legal aid, there has been a massive loss in the amount of not-for-profit, free legal advice available for people on low incomes or in vulnerable groups. In the last 10 years, there has been a 50% loss of provision of not-for-profit legal advice. That is a big loss. That means a lot of the kinds of people that I am most concerned about, who are least able to resolve their problems themselves, do not have, or there's a loss of the services that used to support those kinds of people. This has been a big problem. There's recently been a review of LASBO. The Ministry of Justice is proposing some changes, but like Humpty Dumpty, legal aid is never going to be put back again in the way that it was. So, a focus on technology and innovation. What do we do about the justice gap? I've got a different picture of a justice gap from you. But if we have this justice gap, what do people want and need? How do we bridge it? And I don't disagree with Richard that people don't want to go to court. They don't want to go to a tribunal. They don't even care what the process is. They want their problems solved and they want to be saved. And here is a case in point. Alicia and her baby. Thank you for mentioning my health justice clinic, health justice partnership recently. Alicia was a client in my health justice partnership. Alicia lives in social housing that has damp, it has mice, it has rats, and it has bugs. She had reported this numerous times by email, in person, and by telephone to the local authority. And the reason she had done so is because her baby was suffering. It was suffering breathing problems, and it had constant rashes. She went again and again to the doctor, and the doctor kept giving medicines for the baby, but the baby didn't get better. And then one day the doctor said to her, "Do you know what? You need to go and see these people that we've got in our GP surgery downstairs in the legal clinic." So we set up in a GP surgery in Stratford, a health justice partnership where we were located within the practice, working in partnership with the doctors, and the doctors would refer people to us where they thought a case was appropriate, where they believed that somebody's health problems were underlying people's health problems was a social problem, what doctors call social problems, but because of the education that we had given them, they realised it could be a social problem that legal people might have something to do. So what did we do? We asked the council for an urgent review. The accommodation was reviewed, it was deemed unsuitable, and Alicia and her baby were rehoused. Now that is an example of somebody who did have the capability, who did sort of know their rights, but who didn't have the heft. And the heft, we didn't need to go to court, we didn't need to go to a tribunal. The heft came from people who knew the system actually getting in touch with the council. And that's the kind of work that our Health Justice Partnership does. And the point about Health Justice Partnerships, about putting legal advice in the place that people go, is because vulnerable people who don't know their rights and don't know where to go for help won't just wander in the door. You need to be there in those kinds of situations. This isn't a lecture about Health Justice Partnerships, but I can do one on another occasion. So getting back to technology then, if that's the context, if that's the problem, if this is some of the people that we're focusing on, and my focus is very much on those people who aren't specially literate, who aren't specially capable, and who don't know the ways to sort out their problems, what can technology offer for them? We now have a justice system which is digital by default and by design. And as Richard said, it's going to give us online issue of proceedings, automated triage, document upload, online dispute resolution, online determination, virtual hearings, and as he said, court is going to be a service, not a place. The Master of the Rolls has on numerous occasions told us that the online court will reshape opportunities and it will be one that is more capable of securing equal access to justice for all. That is the ambition, and I genuinely believe that it does have access to justice potential for many people who are currently excluded for the system. So I'm not suggesting that it doesn't have that potential. But in light of what I just said, so that's just a repeat of what's going on in the court. But in light of what I just said about the average reading age of the population, which is 11, and somebody just said to me yesterday it was only 8. I don't know, it's somewhere between 8 and 11. And the large proportion of the population is functionally illiterate. What does the online process look like? Now, I've very kindly been given this slide, which may or may not work, by Richard Goodman, who's the change director at the Ministry of Justice. And if you've got a money claim that you want to do online, this is what it looks like, and these are the kinds of things that you have to do. So if you just watch, you can see how you move through it. And I couldn't find a way of slowing it down, so it's going too fast for you to work. But you can see the range of information. And what do you notice most about it is all the text. There is advice, there's information, there's text. I have to say, I tried it in preparation for this talk. I tried it, but I couldn't get past the password bit. It required, I've got a lot of degrees and I'm quite computer literate, and I couldn't get past the password thing. Richard tells me that was just a glitch and that actually you can. But you can see this is how you would work through that process. Now, I can easily see for many people who currently aren't using the system, that is going to be very good. And I do agree with Richard that one of the real advantages of that is that for intransigent defendants, those people who can pay but won't pay, that actually having proceedings issued in that way may make a difference to behaviour. So when you're talking about those kinds of cases where you've got maybe business-to-business disputes or a consumer-to-business dispute where you've got someone on the other side who's just being a pig and they won't actually engage, then having an online issue of proceedings, I think, will make a difference. That is an empirical question, and I look forward to knowing what the outcomes are. So I think that there are real opportunities for litigants in person, for those people who manage to get themselves into the courts. I think there are real opportunities there. You've got explanations at each stage. The most important thing is that the 500-page white book is embedded into the system. You don't need to know the procedures because the procedures are given to you there through that process. So long as you can read and so long as you can understand the significance of the answers that you give, because the little circle that you blob will take you in one direction as opposed to a different circle that you blob that will take you into a different direction. So it's about can you read it? Can you understand? Do you comprehend the significance of what you do? But nonetheless, I think that there are real opportunities there, and it's quite clear that there are people, this is a voluntary system at the moment, and there are people who are opting to use that voluntary system. As far as tribunals are concerned, there are big changes going on in tribunals as well. The senior president of tribunals has told us that they're moving to continuous online processes, which involve iterative processes, which I think are actually very interesting. This is a process by which the decision maker in the tribunal can actually engage with the party to ask them questions. Now, I've sat in a lot of tribunals where somebody tips up at the tribunal who's had no advice, has got no representation, and the tribunal chair says to them, "Do you have a letter from your doctor?" And they say no. And so the question is, do you adjourn? What do you do? Do you make a decision? That could have been solved through an iterative process that checks that the person is, if they're coming to the hearing, brings all the information that they need, and if they're not coming to the hearing, it gives the decision maker the information that they need to make a decision. So I actually think that iterative processes in tribunals have a lot of promise, but so long as the people who are going through those processes have somebody behind their shoulder who is advising them, because for most of the clients for the tribunals need someone behind them advising them. This is an example of what an online tribunal hearing looks like. This is a test. It's a tax tribunal. I wonder, given how uptight I get when I'm doing a kind of remote Skype thing across the other side of the world, I'm wondering how much less stressful this will be waiting for a tribunal hearing, sitting in your kitchen without anyone there, watching the screen, hoping that the screen comes up. But on the other hand, it has the potential for people who have mobility problems, who aren't going to be able to get to tribunals. I think that this actually does have some real possibilities. Ernest Ryder sees the idea of actual face-to-face hearings is very much the exception rather than the rule. And so it is likely that many, many more tribunal proceedings will be dealt with online, with the decision being given online. And in that respect, I think that the iterative process should be helpful, but that people are going to, again, need a lot of advice about what they say, how they answer the questions, and what information they provide. So on the question of whether or not online court and tribunals increase access to justice, I think undoubtedly for some people it will increase access to justice. For many, many others, we are not there yet. And what we need is technological support for those remaining people who are providing legal advice and assistance for those people who can't help themselves. We have tech programs that are designed to improve legal capability. So there are programs for individuals that are designed to help them to know more about avoiding problems, managing their problems, and the like. And there's this program that I found called A to J, which is a guided interview process. It's a document assembly program which is designed for litigants in person, to help litigants in person. And I think things like that are extremely helpful and will make a difference for the most capable. There are good websites, Law for Life Advice Now, Citizens Advice. They are all better than they used to be. Some of them are a bit interactive and they will make a difference. But I come back to my earlier slide, which is when we're thinking about what do these innovations mean for access to justice, we have to ask ourselves which segment of the potential customer base for the Courts and Tribunal Service are we talking about. And my view is that technology, while technology can supplement and augment for many problems, it is not yet a substitute, and we still have that yawning gap, Richard, between your two bits of cliff or my bit of road. So that brings us to pro bono. So we know that DLA Piper has a massive pro bono program. We know that there is the remaining 50% of not-for-profit providers who are out there struggling to meet the demand with reduced services. What can technology offer them? I think there are real opportunities here. If only we could get the technology people interested in this access to justice end of the market, not the commercial disputes end, but this end of the market, I think there are real opportunities to develop software that will help not-for-profit advisors, pro bono advisors, to extend their reach, to do more with the less that they have, to improve their own efficacy and efficiency. I don't think that the not-for-profit sector has always been as good as it could have been in working out whether it's doing things as well as it could do with the resources that it has. And I believe that technology does present opportunities to improve what they're doing and to expand provision. There are a few good websites that are there, I think mainly available for not-for-profit providers rather than individuals. This is the Royal Courts of Justice advice for litigants in person. This is CourtNav, which is supposed to, again, help litigants in person. And this is PIP information. This is a program intended, I think, for advisors, for not-for-profit advisors who are helping people to apply for these unbelievably complex benefits that replace disability living allowance. So I think that there are opportunities there, and I would encourage any tech people in the audience to think about how you can develop, how you can have a business model that involves actually developing products for this end of the market. And this is a plea to not-for-profit providers and pro bono providers to use the opportunities of technology and data to understand better what they're doing So the people who are providing our advice to some of the hardest to help members of our communities have information in their systems about the range of problems, about the approaches that they have taken to the solution of those problems, and to what works. If they look at outcomes, they've got a much better sense of what actually works. What is effective in achieving that problem solving that people want, and what are the opportunities for service improvement. And so to end, what are the technology benefits in access to justice? I think there are opportunities for information and self-help for those people capable of taking advantage of it. I think there are definite advantages for supporting the delivery of not-for-profit and pro bono services. And I think the online courts offer an easy entry to simplify justice systems and ODR systems. So I think that there are real opportunities, but I don't think, and that's why I think this summit is really good, because I think this is a focus on technology and access to justice rather than technology and commercial disputes. And I'm going to end and say that if you have any questions, I would have said, don't ask me, ask Nadia, who is a chap who's an online virtual assistant who can speak, write and chat online while asking questions. She was developed in Australia to deal with disability, but I've just discovered that she's been put in a wardrobe or mothballed or whatever you do with online virtual assistants, because the technology, I always used to think that talking about online courts is pointless. That's a kind of intermediate technology that is soon everything is going to be virtual with kind of robots. But apparently she doesn't work properly because the technology isn't there yet. So don't ask me, ask Nadia, or don't ask anyone. Anyway, thanks very much.
We do have a couple of questions, but maybe while we wait for the microphone to come around, I might just start by asking a question. I'm fascinated by a couple of things you said. First of all, a 50% loss of not-for-profit legal advice services. And I just wanted to note that in addition to the 50% loss of non-profit advice services, there's been a complete restructuring of the market at that end, because the withdrawal of legal aid has also seen a lot of the for-profit law firms closed down as well.
My other percentage was that it's a 25% in high street solicitors. Exactly. And when the Legal Aid Sentencing and Punishment of Offenders Act was going through Parliament in 2012, they were asked to do an impact assessment, and their impact assessment was that there would probably be about a 70% loss in provision, and that's been pretty accurate. So 50% loss in not-for-profit, 25% loss in high street legal aid firms. That's catastrophic in access to justice terms. We have an access to justice crisis, and my goodness, I see this in our clinic every day. I see it everywhere.
And so it's actually not just people who can't afford to pay for legal services who are missing out. There's also people who can afford to pay something for their legal services who also now don't have access to the high street.
But they certainly won't have anyone, and they won't have anyone close by. On the other hand, I think if you can afford and you are capable and you can read, then I think technology can connect you remotely. And one of the things that not-for-profits are experimenting with is using Skype to do, instead of having people physically face-to-face, using Skype. So an offshoot of My Health Justice partnership is we're doing legal advice for early dementia sufferers, people who have rare dementia at a very early age. And I feel very strongly that people need to have advice to avoid problems happening. You need to get that into the care pathway at an early stage before a problem arises. But there are people all around the country, and we're doing Skype interviews. So we're using, I'm not saying it's advanced technology, but people who can't get into the office, we will talk to them over Skype, and it works. It's better than nothing. There are so many things that are better than nothing.
Do you know if the legal aid providers are using Skype? I know that NHS has got a Babylon app which is connecting people in remote areas with specialist doctors. Is there any attempt to connect people with specialist lawyers who can?
I don't know whether they're doing that, but I sit on an advisory board for the kind of post-LASPO review world, and they have money for legal innovation. and somebody on that with special responsibility for innovation. And I think that they will be looking at those kinds of things. How can we use this kind of little pot of money that we've got to use technological solutions to try and increase the reach of legal aid, specialist legal aid services? Mm-hmm. I hope. I think.
Yes. Just wait for the microphone to come around. If you don't have it. You do? Great.
Good morning, everyone.
Hello.
My name's Mimi Zoe from Oxford Law Faculty. I've recently founded the Oxford Deep Tech Dispute Resolution Lab along with my friend Mark Beer. We try to basically cultivate research talent in Oxford around these sort of issues. So I've got a question for Richard and a question for Dame Hazel. Richard, the gulf that you're talking about, the edge, the lawyers and courts being in the middle, I'm wondering whether you have any insights on I mean, I work with a lot of law tech people looking into blockchain and smart legal contracts, and whether the possibility, I mean, you still need lawyers somewhere, but the possibility actually of removing perhaps the enforcement aspect of that courts traditionally played within the legal system. Of course, smart contracts, we know, not just code, but can actually help to, perhaps in cases like the insurance payouts that you talked about. And for Dame Hazel, I think what's really interesting is also technology can supplement and augment access to justice, but I think what I really appreciated in your presentation was also highlighting that the laws themselves are a source of injustice. And so technology can't possibly address the substance of perhaps, changes to disability, applications, of course, cuts to legal aid, that's procedural, but actually the laws themselves that do not, in the first place, provide substantial rights for the most marginalized and vulnerable. Maybe I got the message wrong.
No, well, I wasn't saying that, and many people say that, and I don't disagree with you. My point of concern here is, yes, we can all argue about what laws we should have that would be more just, but we do have laws at the moment that are designed in principle to provide protections and entitlements for some of our most vulnerable people, and those are not properly being enforced. They are sometimes erratically enforced, they're sometimes erroneously enforced. The number of people who are defendants in tribunal hearings because they're being accused of having been overpaid. I mean, there are. My first step is, let's actually try and enforce the laws that we've got that provide protection so that people get the protection that we've said we want them to have. And then that's another big job to say, okay, let's change the laws as well. So I think I'm more modest in my ambitions and saying I would like to just at least get those laws that we have properly enforced.
Would you like...
if you don't mind.
Yes, thank you for the question. I think there's probably two different senses of enforcement. One, enforcement of judgment, which I think there's great scope for the kind of blockchain technology you're thinking of. My sense of enforcement was rather, how do you move from knowing what your legal rights are to actually having the courts, for example, confirm that that obligation actually is in place. But I do see huge scope for blockchain. And I think that does raise a related point where I would just urge everyone to remember that when you gather in this kind of meeting to discuss technology, in a way it's not today's technology we should be thinking about. If you are in the business of strategic thinking or long-term policy making, you have to imagine, it's that old point about Wayne Gretzky, who said, he was the great ice hockey player, who said he skates to where the puck is going to be rather than where it once was. What we have to try and do in this kind of environment is make the leap to 5 years ahead, where we can expect many of the technologies will be more advanced, people will be more comfortable with technology. And so something like blockchain, I know many people hear about blockchain and think, oh, well, that's got nothing to do with law and lawyers. But actually, it's becoming increasingly mainstream. So the leap we need to make is once blockchain becomes fairly widely accepted in so many different other aspects of our economy and society, why would we not have that as a fundamental building block of the court system? So one almost has to suspend an understandable, it's the same with AI. you suspend understandable cynicism, but the reality is the technologies are not standing still, and in all other areas of life are moving ahead. So it's a fascinating question. So there's quite a lot of work going on around the world about integration of blockchain, even with conventional courts. It doesn't even need to be online courts.
I think Paul has a question. Well, why don't we take a couple? So Paul, if you go first, and then we'll take a question and we'll answer both of them together.
Okay, thanks. Question for, I think, both Hazel and Richard. How confident are you that sufficient priority is being given within the reform programme to the first stage or tier of what Richard was talking about? So that's the bit that helps you work out what your claim is and what evidence you need to prove it. I enjoyed your slide, Hazel, that has the walkthrough of the online money claim system, and I spotted, it's all sort of snazzy with when you're typing in your postcode, but I fleetingly spotted the big blank box for briefly explain your case. Mm-hmm. And lacking was the stuff that hopefully we're about to hear from Shannon, that they do so well in British Columbia, which really does help you work out what category your case is in and what kinds of things are going to help you prove it.
Yeah, Michael from the Bingham Centre for the Rule of Law, and thank you for two very insightful presentations. I was hoping to flag a couple of things to Hazel. In civil society, you often have people providing legal advice to very disadvantaged people who are experts in what they do and navigating the complex institutional relationships, but not necessarily great at evaluations in the sense that a social scientist of your calibre might be expecting. And I suppose my question's around how those sorts of civil society organisations can produce evidence that is robust and credible in influencing decision makers. And also in this really adverse climate where it seems as though access to justice and the rule of law are being undermined by political institutions, how organisations go about convincingly telling the narrative and the story that this stuff matters.
Can I take that one first? Because actually I was just having that conversation last week somewhere else in Europe on a different subject with a politician standing up. So how do you persuade? I mean, how do you persuade? I think you persuade, first of all, with compelling stories. So I think you need narrative, you need compelling stories about what you do, if that's what you're trying to explain them. But you need to underpin it with robust data. And you said to me, how do we do that? And it is, be careful what I say, it has been a constant source of frustration to me that not-for-profit providers have not spent, in fact, the whole of the legal services industry has not been as good at collecting data, analysing data, and demonstrating the value of what they do, which is why we are always at a disadvantage when people like the Ministry of Justice are about cutting budgets. When I set up my little Access to Justice Centre, which is just a microcosm of what lots of other people do, what I said was that data collection and research are integral to what we do. And I have to keep beating people over the head metaphorically about this. So we need to have information about the people who are coming in. What are the problems that they're struggling with? Often more than one. What is it that we did to help them? Did we succeed? What was the outcome? These are not magical questions. They're basic questions. And every organisation should be collecting that information. And at least if you had that, if we could say, these are the kinds of problems we have, this is what we do, these are the outcomes. So it looks like this kind of approach for these kinds of problems might be more effective than another kind of approach. But I don't think that we're there. And I do think that technology is providing an opportunity. So more and more not-for-profit providers are actually having management information systems. I don't know if they're setting them up in a way that they can collect the data and do that kind of evaluation of their services. But if they did, we'd be a long way along the line. Then the other point is that, of course, the online courts are going to be collecting massive amounts of data. And if we want to know how the online courts are doing, we need the Ministry of Justice or HMCTS to be collecting the kind of data that we need. Natalie Byram, who's here, is talking this afternoon, has also been beating them up, I think literally, not just metaphorically, to make sure that they collect the data that we need to be able to say in X years' time have we improved? Have we increased access to justice? And for whom and in what ways? So it's all feasible. We've just got to be concentrating on doing it.
And pro bono providers also
Yeah, absolutely.
are guilty of not collecting enough data.
I mean, I've been to so many, CABs or whatever, where the information about a client, is on the back. It's got post-its and bits of paper with chewing gum on the back. And I mean, just amazed at how poor the record keeping is, because of course their emphasis is putting all of their energies into the face-to-face and helping, whereas and that's great and that's what you want, but you need to be collecting the data. We need the information. And I've forgotten what Paul's question was.
Stage 1, tier 1, is it getting sufficient priority?
I actually don't know. Do you know?
I do a bit, and there's. I was going to say there's two ways of looking at this discussion today. On the one hand, I think it's important, of course, to reflect on the reforms and how they're getting on. But in a way, and maybe this is because how I look at the world, we should also be thinking more conceptually about what it is we can achieve. So if you look at our next two speakers, between Shannon and Margaret, they'll give us fantastic insight, to what's actually been achieved in what you call tier 1 or level 1 in British Columbia, and also that we need to embrace forms of design thinking to make sure that our systems really are usable and useful. There's two aspects, I think, to tier 1, though, to answer your question specifically. One is the idea that Michael Briggs would call online triage, which is essentially, and I've talked about it a little bit, that you have systems that can undertake various forms of diagnosis. And that's like in British Columbia, there's Solutions Explorer, which can help people understand their rights and entitlements. I think that's still at a very early stage in the reform program. The second question, I suppose, is, are they being designed sufficiently imaginatively and creatively to help the many people for whom large bodies of text are often impenetrable? And that's where Margaret's talk comes in. I think there's no doubt HMCTS are alive to the importance of design thinking and moving beyond text to more imaginative ways of interacting. I'm not here to say I've been reviewing the system on an ongoing basis, but I did want to just give one case study, which is perhaps not tier 1, but some of you may know about the success they've enjoyed in relation to undefended divorces. It used to be that in this country, my understanding at least is that a fairly large body of documents to be completed, usually by solicitors, but often by people on their own when they're seeking some kind of undefended divorce. And the rejection rate by the district judges was 40% for mistakes in these forms. It's now gone online and the rejections rate is less than 0.5% of an error. And that's of returns. And that's just an illustration of, this is nothing particularly fancy, but I think a lot of these solutions are not particularly fancy, that we can actually, for the preparatory stages in disputes, we can make the completion even of forms online considerably easier. Now, I've seen these forms and there are still quite a lot of text in them, but they do what useful online forms often do, is they break it down in a way that you've only got 1 or 2 questions each page. It's not particularly forbidding. You can't get to the next page, and yes, you've completed the original page in an appropriate form. But again, I just want us all to think, what might that be like in 5 years' time? How much better that might be with other facilities. I'm going to circle back to the question perhaps again, which is that actually developing diagnostic tools on tier 1 is really hard and very time consuming. So we shouldn't underestimate how difficult that is.
We'll take a last question from Julie Bishop and one over here. So let's take 2 again together.
Okay, hi. I'm Julie Bishop from Law Centres Network. Thanks, as everyone said, really interesting speeches. I have one question and one response. The first question is, Hazel, you talked about Skype advice, and Nick, you said, are there any lawyers actually at the other end? And the answer is yes, it's happening. But remember, Skype is a telephone call. You know, it's what we used to see on the Jetsons, for those of you who were young enough to see it. It's nothing more than a new tool to provide advice. The issue for me, and this is my question, to everyone here is what interests us at Law Centre is how can we, what are the things we need to put in place to make sure that that is a good service provision? You know, what makes that better than someone just queuing up and getting 5 minutes? How do we make that work, and how do we make it work effectively? And I'm really interested, I'm sure people will have done studies on what makes good remote advice, and that's my question. Who knows about that? What is there? I've looked around, there's lots of stuff on the courts, but a general question you may know. So what do we need to put in place, number one? And number two is that it's access, but does it resolve a problem? And so the issue for us is not greater access, but how to ensure problem resolution. And I think you mentioned that a bit, Hazel, in what you were saying. And so my last point is your point about data. There's a heap of data. We all collect data. We collect 50 million different sorts of data for every individual funder. Our problem is not data. Our problem is how do we join that data together? Because Citizens Advice have brilliant data, but then you've got hundreds of other little agencies with their own little pockets of data. And again, this is a question to everyone here. I've asked a number of people here individually to do it. I've been to the London Data Store, I've asked Big Lottery. We need someone to take on setting up a data store for the advice sector data. And I don't want anyone to tell me, oh, the problem's a definition of client. Rubbish. We've got Google. You know, there is an answer. We all collect something different, but we're talking about. So my next question, who is able to take a disparate set of data from across the sector, and once we have that, we can then move into much better learning tools, much better. We can maybe help Nadia because we'll have a much better data source. It's sitting there. But as little tiny advice agencies, my 5,000 isn't going to build that data store. Thank you.
Okay, if I can just ask you to keep this last question brief, because we only have a few minutes.
Oh, I am on. I'm afraid I'm not good at brief, so I'm also going to pick up from Julie Bishop and do a comment and a question. My name is Sophie Walker. I'm the CEO of Just Access. We are a startup, technology company, and we're a social enterprise. We build technology for low-income litigants. My first comment is on the data store. I have a meeting at ODI tomorrow to talk about that exact thing. So if anyone is interested on how we produce a structured data set, this is my plan for the year. Please come up and give me your business card. And I'd like to continue that conversation. The second question is, how many technology companies are here? Okay, am I right in thinking your biggest problem, as well as being data, is funding, right? Like, this is our problem. It's not all these wonderful things you talk about, we could do them, they're not difficult. The problem is we lack the resources to build them. Many of the funding that's being made available in this space is limited to around 50K. 50K buys you research. It doesn't build you anything. So my question for the panel is, how can you make sure that technology companies who are trying to build these beautiful things have the resources they need to do it?
Thank you. We have funders in the room as well. Dame Hazel, would you just like to respond to?
I think it's a question.
There's a number of comments, but if there are anything you'd like to respond to.
I made the point when I was speaking that you need a business model that works for people in the access to justice world. I can tell you that the Ministry of Justice has put aside a massive sum of, I think, £5 million for innovation in this area. So maybe some of that might flow your way. I don't know. So I agree. It is a problem, and we need to think about how we can make a proposition that is attractive, and that means that funders will come in. I don't know. Some of the funders in the room might have an answer. Julie, just on your question about resolution, I agree that the end, we're not interested in process, we're interested in outcomes. What is the point of advice and all the rest of it? It's to solve somebody's problem. How does Skype play into that? my point about Skype is that if you need to get information from somebody through a conversation and you think that a Skype might be better than just being on the telephone or having no conversation at all, that's just a stage in the process to getting to resolution. You don't resolve the problem through Skype, you collect information through Skype. And I think it's a way of reaching more, of using your resources to reach more people, but also for people who can't get in and who can't stand in queue to be able to have that kind of interaction with advisors.
Can I just make a definitional point, and that there's no particular truth in any one definition or another, but I do find often confusion between the terms virtual hearings and online courts, and I usually use the term, when I'm talking about virtual, it's where there is a hearing, but some or all of the participants are using some kind of video link. And that is what we still call a synchronous hearing or a synchronous meeting, that everyone needs to be there at the same time. Normally, when I and others talk about online courts, we're talking about asynchronous process. That's to say it's more like email, where you don't both need to be, or the participants don't need to be assembled at the same time, still that's the same place to communicate. The point is, or one point is, that Skype is just a version of automation. You're often, what people are doing is they're saying, rather than meeting in person, we'll use a video link. Whereas the idea of the online court, which is asynchronous, is more of a transformation. That's saying that there actually is no physical hearing nor any virtual hearing. And not anything of particular follows from that distinction of itself, except the mindset point that very often people throw Skype at a problem. Essentially what they're doing is achieving mess for less. The process is messy, and they use technology just to take some of the cost out. What again I want to encourage people over the next day to do is to think not just about using technology to streamline, but it's also my transformation point. And that's where the asynchronous process comes in. And that's where, when you hear what Shannon's been doing, it's not an automated or Skype version of court. It's something quite different.